Well, good afternoon, and thank you for joining us today for our Abbey Legal MGAA members' discussion market briefing. I'll ask Robert just to explain the relationship between Abbey Legal and LHS.
Abbey Legal is an MGA providing legal expenses insurance, access to advice and litigation when you have a legal expenses solution or problem. We own, or the technical word is, we are a corporate member of LHS Solicitors, having come involved with legal practice a couple of years ago. And we always supplied Abbey Legal Services through our legal expenses products. This was rebranded on the 1st of March as LHS Solicitors. Robert and John are part of LHS Solicitors.
Thank you for that. So it gives you a quick, brief relationship between the two. If you're wondering why LHS are here, they are here because they're the ones that know everything that we really do need to know. So today's talk is actually by Robert Dempsey and John Warren from LHS. It's estimated that the largest cost of any business, whether they're regulated or otherwise, is their employees. We have seen a continued development of the employment legislation through successive governments and also the results of the tribunals themselves. Today, Robert and John will walk us through some of these changes and, more importantly, what's actually going to be coming up on the horizon. We asked for their biogs because it's always interesting to know their backgrounds, and we're told that Robert is an experienced solicitor and has specialised in employment law and has been at Abbey Legal since 2001. He has vast experience in employment tribunals and is often called upon to assist in complex dismissal as well as 2P and the discrimination matters. John is a new boy. He joined in 2007 and is also involved in the employment law, especially with regard to businesses. He too has vast experience in 2P and disciplinary processes and also redundancy. John has a Master's in employment law and was awarded distinction in 2004. Ladies and gentlemen, your speakers for today's session.
Thank you. Well, first of all, I think we'll just briefly introduce our particular roles within LHS as well. I think that would help give a little bit of context to what we're talking about here. John, in particular, deals with the contract side of things, contracts of employment and complex dismissals, settlement agreements and the like. And
Robert, in comparison, has probably spent the last decade actually in the tribunal. He's a litigator and he's spent all those years defending employers to claims for unfair dismissal, discrimination and a range of other claims.
So we're sort of a bit like the alpha and omega of the employment process, in the sense that John advises on recruitment, advises on contracts, and I end up fighting cases when it all goes wrong. So that's the way in which...
Not my cases.
No, not John's.
In an ideal world.
That's the way in which the setup works within LHS. As we've heard, we'll hear questions at the end, but if anyone has any particular insurance questions, it's probably best to raise them with Robert, and he's happy to address any of those. So let's start with what we're here today to discuss. Broadly speaking, we're talking about risk, but on a wider basis, we're talking about risk in the context of red tape and the attempts over the past 5 years by the previous coalition government and hopefully going forward by the current government to remove red tape surrounding employment law and employment issues. What we're going to be looking at in particular is how there have been potentially unexpected consequences of that change, and we hope to give you some guidance for insurance businesses on navigating a constantly changing employment law landscape. I have to briefly go through the learning objectives, and hopefully by the end of the briefing you'll understand this has been a period of pretty astonishing change in employment law since 2010. In your packs you will find an infographic which sets out a very brief précis of the sort of law and legal changes we've seen since 2010. As you can see, it's pretty extensive, lots of things favouring employees, lots of things favouring employers, other things neutral. We also want you to be aware of the potential impact of the big events looming, including the referendum and Scottish devolution, which is likely to have an impact on employment law. And hopefully, if you leave with anything today, it's that we hope you have a better understanding of how good housekeeping in terms of employment law, getting contracts in order, getting the basics right, is absolutely crucial to avoid risk in an employment context. So, where are we now? Well, we're at a bit of a crossroads moment. Obviously, we have a new government. When the coalition government came in 2010, they started a process which could be described as a bit of a clear-out of different legislative cupboards, and what we're looking at today is, in particular, the employment law cupboard. The challenge was to create a bonfire of over-burdensome legislation and red tape. It's still burning, that bonfire, but what we're going to be discussing today is how this astonishing period of change in employment law and this arsonist's approach to existing legislation, scrapping lots of old legislation and introducing a smaller amount of new legislation, hasn't necessarily had the intended effect of reducing complexity in the employment law field. I've talked already about the importance of getting the basics right, and I will be drilling home the importance of that. It is absolutely crucial. Quick show of hands, how many people here do not have contracts of employment? Does everybody have a written contract? Well, that surprises me, I must say. My experience is that a very large number of people, certainly in employment tribunal, by the time I get there, do not have contracts. And often when someone rings me up with an issue to discuss, they will say, I will say, can I have a copy of the contract? And they go, there isn't one. And that causes huge problems right from the outset. But sensible contracts, sensible documentation suited to the business and regular audits will solve a huge amount of problems. And we're also going to be touching on the unintended consequences of well-meaning policies. The road to hell is paved with good intentions. The previous coalition government had lots of bright ideas about how to make things nice and simple and straightforward in employment law, and to a degree, it hasn't quite worked as intended. When we were preparing this presentation, we talked a lot amongst ourselves about squashed balloons, and we almost labelled this presentation squash balloons, but decided it might lose people. The idea here is that if you squash employment law in any particular direction, it bulges out elsewhere. There's a natural balance built into the system, in the sense that if you attempt to change the law too much, people find workarounds. If you move the goalposts, they'll move with you. And what the government has tried to do, broadly speaking, is to reduce claims and to make things more difficult for employees to bring claims. They've found new ways to do so. Employees are becoming extremely creative in bringing complex and difficult claims, and there are many ways in which the simple solutions the government has introduced have inadvertently created far more complex problems. A good example would be the way in which employees are now required to have 2 years' service before they can claim unfair dismissal. Previously, they only needed 1 year's service. But that, unfortunately, has led to cases becoming more complex because employees look for ways to bring a claim when they have less than 1 year's service. If you've only been there for 6 months, you can't claim unfair dismissal, so you bring a discrimination claim instead. That's happening an awful lot. Also, we have the introduction of ACAS pre-claim conciliation, a nice idea of the government to force people to employees to engage with ACAS in an attempt to settle their claims before they go to the employment tribunal. A side effect of that I'm seeing a lot in the litigation field is that in light of that, it's now very difficult for an employer to get a case struck out early on the basis it's out of time. Routinely, 10 years ago, I was getting a lot of cases struck out. That's not happening. And then we have areas where there's been actually completely missed targets, in my view. It's an opinion, but, for example, the government has introduced settlement agreements to replace compromise agreements. I'm sure everybody is familiar with the concept, if only in concept, of a compromise agreement or a settlement agreement. It's a payoff, a legally enforceable payoff. But the government has introduced changes to the system which have not quite worked, and we'll discuss those in more detail shortly. And we'll also touch upon the controversial introduction of employment tribunal fees, which have led to a reduction in employment tribunal claims, but we'll be hearing how that isn't necessarily the be-all and end-all of the picture, and how employment tribunal claims have probably troughed and may start to creep up again a little bit now. And then finally, we'll touch upon new challenges, changes in employment law that are likely to happen, a bit of crystal ball gazing. We'll try and discuss how these are likely to impact upon businesses and the impact of major changes like the referendum, Scottish devolution, 0 hours contracts, and changes in strike law. So those are all issues that we'll be discussing during the course of this talk.
We're now going to start to review some of the significant reforms of the last 5 years. We'll be assessing the impact on both employers and employees, and assessing really whether they've worked in practice or not. We're going to start with the reform that was made in April 2012, and that was the reform to the right to claim unfair dismissal. It can be seen as the moment that the bonfire to red tape was really lit. The reform was that basically employees in the past had been required to have just 1 year's service to claim unfair dismissal. As a result of this reform, they now needed 2 years' service. What that meant in simple terms is, for example, if you'd worked for 1.5 years, you now could not claim unfair dismissal. So, in practice, that did make it easier for many employers to dismiss their employees, particularly during the second year of service. What clients of ours have said is, in the first few months, first year or so, you tend to see a honeymoon period where employees are motivated and they're doing their best in the job, but after that honeymoon period there's a decline sometimes, and this reform really did help employers. Despite that, there have been some problems with this reform. We have noticed that in the claims that are being brought, they tend to be a lot more complex, and the claims that are being cited are those that don't require any length of service. What I mean by that is, firstly, there are what's called an automatically unfair reason for dismissal. There are in fact 31 of these. As examples, if you probably all know, if you're pregnant and you're dismissed for that reason, it's automatically unfair. I could go through them all now, but I won't bore you. Other examples are, this can commonly happen. An employee may need to take time off to care for a child or other dependents, and they are then dismissed. And whilst this is possibly not the reason, and probably not the reason for dismissal, an employee can easily argue that they were dismissed because they'd asserted that statutory right to claim unfair dismissal. So that right to take time off to care for a dependent. In addition to the automatically unfair reasons for dismissal, there were discrimination claims. So an employee could say they'd been discriminated for reason of their age, their race, sex, religion, disability. They don't require any length of service.
I mean, this is really where the action is in terms of employment litigation. The government's plan to make it more difficult for employees to bring a claim of unfair dismissal by increasing the length of service from 1 year to 2 years, the required length of service, has worked. It has reduced the number of claims. But the claims we're getting are far more complicated and far more difficult to deal with and far more expensive to deal with. I mean, when I started in employment litigation in 2004, after moving from general employment advice, the cases were very simple. You would have a 1 to 2 day case involving, typical scenario would be an employee who'd stolen something from an employer or who had got into a fight with another employee. Very straightforward, factual scenario. Now what you get is employees working a long way in advance to set up the employer to fail by raising health and safety issues in advance, by raising protected disclosures, by keeping detailed diaries of discriminatory events and setting the employer up to a degree to fail. I mean, I have seen, for example, cases involving 75-point grievances spread over 10 or 11 years where the employee complains about everything that's ever happened to them the whole time they've been there and deliberately attempts to link each complaint to one of the 31 automatically unfair reasons that John has spoken about. That employees now wind up to a claim. So what would have previously been a 1 or 2 day case in the Employment Tribunal is now becoming a 6 day case or a 7 day case or a 10 day case involving umpteen witnesses. There are fewer claims as a result of the government's changes. Those claims are more expensive and more complex to deal with. I mean, examples we've seen would be health and safety complaints. An employee would say, all right, you are accusing me of stealing £100,000 from the company over a 4-year period, but you will recall that last year in conversation with you, I mentioned there was a box in front of a fire escape. Therefore, you are subjecting me to a detriment because I've raised a health and safety issue. Therefore, I'm bringing a claim on that basis. And rather than sit back and wait for you to sack me, I will jump now and claim constructive dismissal and claim I'm being automatically unfairly dismissed. That sort of thing happens. Whistleblowing, you may have a complaint to a financial regulator. An employee may put in writing an email to cover his back in advance of a feeling that he is about to be managed out. And discrimination. Discrimination claims are still very common. Discrimination can take, as John has pointed out, a very wide variety of forms: race, sex, age, religion. anyone can claim discrimination in some form against anybody else. And I think that there is a perception that discrimination legislation is brought by, a certain type of person. That is not true. Everybody brings discrimination complaints, and I've seen a huge number of discrimination complaints. We've seen a sort of evolutionary arms race appear in terms of the way people have adapted to the change in the law. And what's happened is that they're making cases more complicated, and there is plenty of guidance out there on the internet to help them do that. So you'll see, for example, online, if you Google grievance letter, you'll find websites with names like grievance.com, and they'll have template 45-page grievance letters citing everything going on for years and years, and at the end it'll say, give the bastards hell. And that sort of thing happens all the time. So cases are more complex and difficult to defend on that basis.
We're now going to look at one of the other reforms that was made by the government, and that was again in 2012, and it was changes to the way in which apprentices are employed. The purpose in making this reform was to really give employers greater ability to dismiss apprentices, particularly for those who are not performing very well or had maybe committed acts of misconduct. And the reason for this change was, historically, it's been very difficult to dismiss an apprentice, simply because when an employer recruits an apprentice, not only do they enter into a contract of employment, they also enter into what's called a contract of apprentice. And what that basically means is the employer would have special obligations to the apprentice over and above what they would have to a normal employee. There's an extra level of protection there, and there are some extreme examples where if you dismiss an apprentice who has possibly not been performing very well, the apprentice may not just bring a claim for unfair dismissal, but they might bring a claim for notice pay for the duration of their contract, and that could be for a period of 2 years. And that's an extreme example, but employers had sometimes seen that, and there was a certain amount of fear amongst employers in taking on apprentices. In my view, the changes that the government made have been very effective in this area. What they introduced was what's called a prescribed contract of apprenticeship, so known as a government apprenticeship. And if the employee was placed on this contract in accordance with statutory criteria, then the employer could relatively easily dismiss that person during the first 2 years of service. They wouldn't have the fear of these horrible claims for notice pay for 2 years. The difficulty that some employers have had, though, is not being aware of this distinction. They may know there has been a change in the law, but they possibly didn't put the employee onto the correct contract. We've helped employers ensure they have the right contract, and we've seen by using our contracts and also complying with the guidance we've given, they've been able to successfully dismiss employees very easily if they're just not showing sufficient promise as an apprentice. And I would say that one consequence of this is employers have been much more confident to take on apprentices, because clearly apprentices have a valuable role in companies, but prior to the change there was just uneasiness taking them on, and that's been a positive change for employers and also apprentices.
Okay, I'm briefly going to talk now about settlement agreements. We've touched on settlement agreements briefly, but we're going to have a slightly more detailed look at them now. Settlement agreements are... You've probably encountered settlement agreements and possibly not known about it. If you've had a colleague mysteriously vanish and nobody ever speaks about them again, it may well be that their employment has been terminated under a settlement agreement. This does happen from time to time. They used to be called, until July 2013, compromise agreements. And for some reason, the coalition government felt it was appropriate to rename them as settlement agreements. It's a very cosmetic change, just the name. But they did introduce a couple of changes, one of which we'll really talk about in detail here, which have changed the way in which these settlement agreements are advanced to employees. What they intended, the government, was to introduce something called a protected conversation. The aim of introducing that was to provide a mutually beneficial way of ending the employment relationship without the cost and stress associated with an employment tribunal. which is a lovely idea. It's not quite worked in practice. Settlement agreements are contracts between employee and employer. You are approached by your employer, and the employer says, can I have a chat? It's not really working out. We'd like you to go, and we'd like to offer you X thousand pounds for you to go, £10,000, £20,000, £100,000, £200,000. I've been involved in settlement agreements, I'm sure John has too, of very high value and very low value. And the amount of money is up for grabs and totally up for negotiation, as in any other contract. What's changed recently is the way in which those settlement agreements are introduced to an employee. The old law with compromise agreements was that you had to have what was called a without prejudice conversation. So there had to be effectively, in order for that to work, however, under the old law, a bit of a dispute going on between the parties to justify a without prejudice discussion. Because what would often happen is employers would call an employee into a boardroom, slap a contract on the table, settlement agreement, and say, you're going under that. And the employee would then resign and claim constructive dismissal and win, because the employer is not giving them an option. There's no option there. Now, if they have a reason to dismiss the employee, say the employee is not performing or has committed an act of misconduct, a fair way to go about initiating a without prejudice conversation would have been to say, look, John, can we have a chat on a without prejudice basis? We have option one. I believe you've committed an act of gross misconduct justifying your dismissal. We can go through a disciplinary procedure which may or may not lead to your dismissal. Or option two, we can go the settlement agreement route. Which do you want? That only works, however, where there is an active dispute between the parties. So just approaching the employee cold and saying, we want you to go, that was always problematical. And that's what protected conversations are attempting to address. So the government introduced this lovely idea of the protected conversation, where you say to the employee, we are now going to have a protected conversation, and we would like you to go under a settlement agreement. And all is well, you can actually say that to an employee now under a protected conversation. Well, no, it's not worked. And the reason that that's not worked very well is because protected conversations don't apply in respect of automatically unfair dismissal cases of the type that John has talked about, the 31 types of automatically unfair dismissal. They don't apply in discrimination claims, and they don't apply in breach of contract claims. So if you approach an employee as an employer and say, we're having a protected conversation, I'd like you to go, and here's a settlement agreement. If the employee then says, I'm pregnant, or I believe you're doing this because I've raised health and safety issues previously, then you're potentially facing an employment tribunal claim. The government has introduced what it thinks is protection for employers in terms of protected conversation. Unfortunately, the devil is in the detail, and it's not the protection the government thinks it is. And in practice, what we're seeing is employers have had to adapt to, you now have two choices in how you approach an employee in terms of initiating a departure. You have a protected discussion, which really only is appropriate, it can work, but is only appropriate with employees where there is no problem, no axe to grind, where you have a good working relationship. You can have a protected conversation with an employee there and hopefully not face a discrimination complaint. Alternatively, if there is any kind of problem with the employee, it's not safe to initiate a protected discussion. It's safer to go the without prejudice route and have an on-the-record approach to the employee saying, your performance is poor, we're going to put you on a performance management route, or on a without prejudice basis, as an alternative to that, we can do a settlement agreement. So what's happened here? Well, the protected discussion, the changes have made everything more complicated. In terms of reducing red tape, I'm afraid this is a missed target. It's completely failed. Although protected discussions can work in certain situations, on the whole they have made employment law more complicated as opposed to less complicated. So if we're in part assessing the government's approach and its performance here, that aspect amounts to a failure. You now need to get pretty detailed legal advice in order to depart an employee. Simply having a without prejudice conversation, calling it a protected discussion, is not the cure-all or the silver bullet that employers probably really needed.
Probably the most controversial of all changes made in the last 5 years by the coalition government was the introduction in the summer of 2013 of employment tribunal fees. In addition to saving the Ministry of Justice quite a lot of money, the government's stated purpose was that the reform would deal robustly with cases with little or no prospects of success. In announcing the reform, George Osborne at the time said it's time to end the one-way bet against small businesses. There was a sense that it was all too easy for employees to issue claims regardless of prospects of success when a claim arrived and the employer saw it, even if there was reasonable prospects of defending the claim, quite often employers would just think, let's say, the time, expense, and think, well, we'll just settle. So money was being given to employees when there was really no reason to. An employee must now pay quite a high fee to issue a claim. Depending on the complexity of the claim, there will be a fee of between £160 and £250 just to issue the claim. If the employee actually wants the claim to be heard in the tribunal, in front of a judge, there's a further fee of £230 to £950. That is a lot of money for someone, particularly when they've lost their job, and it is posing a big deterrent. In addition, there's been some changes to what's known as the remission scheme, which is really an arrangement where people that, depending on their financial circumstances, are unable to afford the fees, and once assessed, they may not have to pay the fees. Changes that have been made to that scheme have made it much more difficult for employees to issue a claim without a fee. So what have these fees done? Well, it's true to say that it has resulted in a marked reduction of fees, a marked reduction of the number of claims that have been issued. So if we look at the 3-month period just before the introduction of fees in 2013, there were in total 340,000 claims issued across the country. If you then look at a later period after the fees have been introduced and once things have settled, there was a reduction of almost 70%. So large. 110,000 claims issued in that period. Okay. Despite the introduction, there have been some differences throughout the country. So it's not a blanket reduction of 70%. For example, there was data in 2014 that showed in the East London Tribunal that would really be dealing with lots of claims that emanate from the city. There was a reduction of just 20%, it was said, and we can draw our own conclusions as to why, but I think it's likely it's because the fees set at that level are not as big a deterrent to high earners in London compared to, say, other parts of the country.
I think that the headline message to take away from this one is not, however, necessarily there's been a 70% drop in employment tribunal claims. I mean, I must admit, I'm an employment tribunal litigator, and there was a certain amount of concern amongst the employment litigation community that, you know, our rice bowl is broken and that all the work has gone away. But I'm still here. The cases are still coming in, and they're getting more complex and they're getting more difficult, possibly because there's fewer of them. There's a lot of factors that feed into how employment tribunal litigation has developed during this period. I mean, we've had the recession as a backdrop, which I think also has influenced the degree of the drop in tribunal claims. I think the drop in tribunal claims has troughed, and I think what we're going to see over the next few years is a gradual increase, not to the previous levels, but employment tribunal claims are still going to be brought. It's clear fees have discouraged employment tribunal claims from being issued. But I think, in terms of workload as a litigator, it hasn't dipped in the sense I've now got fewer cases, but they're a real pain in the neck to deal with. They're much more difficult and much harder to win. Are we left with just the tough cases? Have the tribunal fees worked in that sense? Well, not necessarily, no, because if you look at the statistics, still about as many cases are being won, and still about as many cases are being lost. It's not like all the weak cases have gone. All that's happened is, I think, a large section of the community who can't afford to bring tribunal claims are now not bringing employment tribunal claims. If that's the government's intention, it's worked. But it's not necessarily reduced the burden on employers to the extent that I think the government intended. Other factors we find are that settlement can be more difficult these days because people, in terms of fighting their case, their views often harden because they've paid more money to bring the claim. Settlement is at a slightly higher level because you've got to factor in the fees. Fees don't necessarily always follow the event. You don't always get your fees back if you win, but the employee wants that money back when they settle. Settlements are for larger sums. We've noticed a 20% increase in our settlements, so more cases are settling. And there are other factors to bear in mind as well, which we'll be touching on in more detail, but the current fees regime is being appealed by Unison, who regard it as unfair and discriminatory. That case is actually being heard at the moment. It was heard yesterday and today. We may not get a result on that one until the autumn, but the government has also announced a review of the current scheme, which could result in a reduction in the fees. Fees, I think, are here to stay. So the total number of tribunal claims is going to be down on its sort of 340,000 high, but it's going to gradually creep up over the next few years, I think. In terms of resolving these issues, as always, basics are key. Go through a fair procedure, make sure that if you are dismissing employees, seek advice, avoid any steps which could complicate the employment relationship, avoid discrimination, get your contracts in order. Simple ways actually solve most of the problems in avoiding issues in relation to the employment tribunal.
Okay, we're now going to look at what's called early conciliation. And this was introduced by the government in 2014. ACAS, as you're probably aware, is a conciliation service, and they're there really to attempt, in this instance at least, to act as a middleman between employers and employees, resolving disputes, and in the early conciliation remit, to stop matters actually being issued at the tribunal. It's very important at the outset to remember they're not there in the capacity as advisors, either to employees or employers. So they're not on anybody's side. So the reform that was made in 2014 was to ensure that for every employee, before they go to the tribunal, they must contact ACAS to make them aware that they're considering issuing a claim. Normally they would submit a form online, but even that wasn't necessary in all circumstances. You could pick up the phone to ACAS and an officer would even fill in the form on your behalf. Once that form is received, then the ACAS officer will contact an employer and explore the possibility of settlement. There's no obligation on either employee or employer to enter into negotiations. If they choose not to, a certificate will be issued, and then when the employee later issues a claim at the tribunal, they simply show that certificate and they can pursue whichever claims they choose to. The government announced that this would go a long way to ensuring that claims are settled without cost and stress to both parties. In my view, this has encouraged many employees to pursue settlement in a way that previously they wouldn't, in some cases. It's very easy to pick up the phone, as I've just said, to ACAS, and before you know it, the employer is having to defend all sorts of allegations without the employee even having to issue a claim at the tribunal. How do employers deal with these calls? In my view, it's actually a useful mechanism for some employers, particularly if we're talking about small value claims, perhaps an omission made by payroll to deal with holiday payments or notice pay not being made and the company accepts that there was a failure on their part. If you use ACAS here to settle a matter, it's not going to cost you any money other than the contractual sums you would have had to pay, and the matter's resolved easily without the cost and the trouble of dealing with a claim. However, the concern arises when we're talking about more complex and difficult claims. So some of the claims we've been talking about earlier today. So if there could be a claim for unfair dismissal or discrimination, you need to be extremely careful not to make any admissions or concessions in these discussions with the ACAS officer, because that can actually prejudice your ability to defend a subsequent claim issued by the employee. One of the difficulties employers face is they don't know what claims are going to be issued. So sometimes they say things without really contemplating what could be thrown at them a few weeks later, and that can really damage their position. Our recommendation would always be to consider the situation carefully and, if necessary, take advice before speaking to an ACAS officer who really can actually damage in the long term your position there.
And from my perspective as a litigator, the ACAS conciliation, early conciliation, is making it harder to get cases struck out at an early stage, because the government's changes mean employees now have a longer time to bring a claim because they have an extension of time to explore conciliation, and cynical employees are exploiting that by just using that time to cause problems. So just moving on now, we're going to look at whistleblowing. We've already had some discussion about whistleblowing. The government has amended whistleblowing legislation in light of perceived problems with it. There is earlier whistleblowing legislation. If you are, I don't know, the captain of the Herald of Free Enterprise and you think it's not a good idea to drive around with the bow doors open and you want to raise that with your employer, you're a whistleblower. That's the classic example. And the government's legislation is intended to address that kind of very serious whistleblowing. In practice, I find day to day at the coalface of employment tribunal litigation, it's being abused. And in terms of growth areas, this is the one enormous area of employment litigation that's just snowballed over the past 5 years. It seems like virtually every other case I have now has a whistleblowing element to it. And this is an example, as we spoke about, the evolutionary arms race that's happening between respondent lawyers and claimant lawyers. Claimant lawyers now slap in a claim for everything, and whistleblowing is top of the list. There were a number of perceived problems with the earlier legislation about whistleblowing. One of the perceived problems was that, for example, I could claim whistleblowing if my own contract was breached by the employer. That's an issue personal to me and my employer. Why should I get the protection of government legislation in terms of a dispute between my employee and the employer? I'm not a whistleblower. I'm just complaining about my contract. So in June 2013, part of the Coalition's changes to existing legislation was to introduce a new public interest test, so that if you whistleblow, it has to be a wider interest than just you. That was closing a perceived loophole in the law. There was a removal of a previous good faith test. A lot of cynical employees, I think the government anticipated when they initially introduced this legislation there would be cynical attempts to manipulate it, so they introduced a good faith test. Didn't work in practice, far too complicated, so that's been removed. However, there is a power for the Tribunal to reduce awards for cynical employees taking advantage of this legislation. And there's a new personal liability for a co-worker who victimises a worker. And now, for example, if you employ two employees and A victimises B because he's raised a whistleblowing issue, you, the employer, can be vicariously liable for the actions of that employee, which is a bit of a painful change for employers. Whistleblowers will now only be protected from dismissal, selection for redundancy, etc., or suffering a detriment if they can prove to the satisfaction of the Employment Tribunal that they reasonably believe the disclosure they have made is in the public interest. The problem with the changes the government have implemented is that public interest was not defined. And in practice, I'm finding that public interest is defined very broadly. If you have a minor gripe with your employer, there is always a way to spin that as being in the public interest, to complain about it in the sense of being a health and safety issue or a regulatory issue or of wider public interest. It's not difficult to get past that limited hurdle. We are seeing, as I say, an avalanche of such claims. And in terms of responding to these claims, they are very difficult to deal with. These are where you see 100 separate instances cited by the employee of whistleblowing over a 10-year period. And as a lawyer, you have to deal with each one of those and gather evidence to respond to each one. Hugely time-consuming, hugely expensive cases to fight. How do you avoid these cases happening? Well, again, back to basics. Get your whistleblowing policy in place. Have a good set of contractual documentation, a good staff handbook that sets out very clearly what to do when you have an employee raising these issues and a procedure for dealing with it. This type of case is certainly being used to get round the 2-year limit on unfair dismissal, and to that extent, I have to say, this bit of legislation hasn't really worked in reducing the burden on employers. So we're going to have a quick look now to talk about the future of employment law and the impact that's likely to have over the next 5 years.
So after May's general election victory for the Conservative Party, I think it's fair to say we can expect to see policies that are intended at least to be both pro-business and anti-trade union. What does that mean? Well, one of the first items to be on the legislative agenda is in respect of strikes, and in particular to make it a lot easier for, a lot more difficult for unions to actually succeed in strike action. No doubt you've all heard Boris Johnson over the last few years talking about the need to reform strike law. Commuters have suffered a lot. The key changes being proposed are that in future it would require, if this legislation is passed, it would require 50% of all eligible voters to actually vote in a strike action. And history has shown us that that often doesn't happen. In addition, in key public sector areas, there would be a need for 40% of eligible voters to vote in favour of strike action. That's going to make it a lot more difficult, as I've said, for the unions. In addition, there are proposals that the ban on agency workers during strike action would be lifted, making it a lot more easy for employers to cope with the effects of a strike action. And there's further proposals to deal with intimidation by the unions in a strike period. We're also going to consider 0 hours contracts. Many people perhaps see this as an issue associated with Ed Miliband and the Labour government, and as a result of them not winning the election, it's not on the agenda. That's not quite right, in the sense that the Conservatives are making proposals, albeit not as major as what the Labour Party were proposing. One thing that has already happened is, just a few days after the election victory, the government has introduced a ban on exclusivity clauses in contracts of employment. 0 hours contracts simply say to an employee, we're not going to give you any guarantee of hours during your employment. So 1 week someone could be working 40 hours a week, next week none. For those employees that wish to work elsewhere, if there's an exclusivity clause in the contract, they can't. So this ban has come into force. We haven't yet seen what penalties will be imposed on employers, and I think it's likely that there will be further regulations to ensure that there are some penalties imposed on employers, but also there will be an extra claim available to employers if they suffer a detriment as a result of having such an exclusivity clause and they take a job elsewhere.
I mean, the difficulty with what potentially could be, we don't know yet really, a bit of a knee-jerk reaction to a perceived political need in respect of 0 hours contracts is we don't know what shape the legislation will inevitably turn out to be. And it is quite possible there'll be lots of, from an employment lawyer's point of view, lovely satellite litigation about this. So the government will define an exclusivity contract, and then 200 employers will try different ways of putting, exclusivity clause, and they'll try and come up with new exclusivity clauses that are not called exclusivity clauses, or restrict an employee in new ways, and exciting new ways, that then everybody has to then litigate over. So this is another example of the unintended effect of trying to simplify everything, and that often, in practice, it doesn't work. We'll have to see. It's something to watch for the future.
We're now going to look at the issue of Europe. As we all know, the government are proposing to renegotiate Britain's membership of the European Union and then hold a referendum before the end of 2017. What we don't know, however, is the precise proposals being made by the government for renegotiation. Obviously, ideas in relation to reducing the entitlement to in-work benefits is on the agenda. There are other proposals in respect of making it more difficult for other countries to agree changes to the EU that Britain has to agree with. Ideas for vetoes are included, no doubt. In terms of employment law, the area is a bit grey, and in the last few years David Cameron has talked about reducing red tape and the burden on businesses, but there hasn't been a huge amount said about what would change in terms of mandatory EU labour law and how it applies to Britain. What you might see perhaps if there was some type of renegotiation, which I think is likely to be difficult because of issues to do with treaty change and the difficulties there, but if there was some change, you might see proposals for changes to working time and holiday entitlement. For example, the restriction on the number of hours you can work each week. I think what is more likely, however, is a compromise, perhaps heralded as a triumph by the government, and then there's a referendum. But actually the likelihood there is there would be little change if there was a yes vote in favour of staying in the EU. By contrast, if there was a no vote, I think it certainly opens the door to the possibility of major reform. That would be dependent on the government that is in power at the time, because we don't know how long this process would take for Britain to withdraw from the EU. But what you then could see is the possibility of changes to any of the laws that have emanated from Europe, whether they be discrimination ones, whether they be laws relating to collective labour arrangements or transfers of businesses, working time, as I just said, rights in relation to part-time workers, fixed-time workers. In my view, and I think Rob would concur, this may well be a bit of a red herring, because whether there's a yes vote or a no vote, changes are likely to be slow and they're likely to be cautionary at first. No doubt case law will also affect the way in which reforms are carried out.
One other area of reform which we may see some changes in over the next 5 to 10 years or so is Scotland. The Smith Commission was given the task of recommending further devolution powers to Scotland, and a new Scotland bill has been published before the general election, under which power was to be devolved to the Scottish Parliament in relation to the administration and management of the employment tribunal system. And that is obviously going to have, that bill has been taken forward by the government. It seems to me that's likely to have a significant potential impact on employment tribunal fees in Scotland. So we've seen this significant drop in tribunal claims as a result of fees throughout England, Wales, Scotland. If Scotland goes its own way on employment tribunal fees, which it probably will, then we're going to see claims from Scotland creep up, probably disproportionate to the rest of England and Wales. The Scottish Government will probably be able to decide the level at which the fees are set in Scotland. The Scottish National Party has been critical of the fees regime, so we are going to see a decrease in fees in Scotland and likely, therefore, an increase in Scottish claims. Bear in mind as well, Northern Ireland doesn't have a fees regime at all at the moment, so we're still seeing plenty of claims from Northern Ireland. Employers will need to keep an eye on Scotland, and it may perversely become, as a result of the Scottish policies, more painful for employers to employ people in Scotland. So you may see a number of employees in Scotland being dismissed for that reason, and more claims in the short term. So that's another thing to watch. We mentioned, in terms of other issues, briefly to touch on, we touched briefly on the current, going on at the moment, judicial review of employment tribunal fees. If that judicial review is successful, it seems to me a possibility, fees are likely to be reduced with a likelihood of an increased number of claims. And the government is currently undertaking a review of the impact of the fees regime in light of the significant drop in tribunal claims. The review is probably a bit of a fig leaf, so they can say that they've done a review before any actual steps are taken to address it. It's effectively an internal review, and if the review comes back with any conclusions, they will then cast their net wider and do a proper review. But it seems to me that there is going to be, over the next year or so, certainly by autumn, some further movement, potentially a lot of further movement on employment tribunal fees, hence potentially claims are going to start going up again. We'll be monitoring that situation very closely. So, conclusions.
The government hoped that the reforms they would make would give businesses the confidence to take on new staff in a climate where the burdens on them have been reduced. In my view, I would say that there have been a lot of helpful changes for employers. For example, the introduction of fees has reduced the number of claims issued against employers dramatically. Early conciliation has as well contributed to a decline in claims. There have also been some important measures taken in terms of the rise in number of years required to claim unfair dismissal from 1 year to 2, and the introduction of the Apprenticeship agreement that has made it easier for employers to dismiss employees in particular circumstances.
The reforms have also resulted, as we've seen, in unintended consequences that were unplanned by the government. We have employment law is intensely political, and it pendulums depending on which government you currently have at the time. What we've seen is a lot of employee organisations, unions and the like, adapting to the government's changes by making new types of claim, more complex claims, fewer claims, and therefore more expensive claims. And we're seeing that pattern time and time again in day-to-day practice as employment litigators. Employers also now need to be far more careful in terms of approaching employees with severance packages than they had previously. The situation's not been improved by the government's reforms, frankly, and that's not necessarily worked. The problems the government has faced in trying to simplify the law highlights the complex nature of employee rights in the UK today. Different dimensions of changing domestic legislation, changing case law and European law means there is still plenty of problems out there. The one phrase I hear repeatedly from clients in terms of employment law is minefield. That term crops up over and over again. The government has cleared out quite a few mines, but there's still a few out there, and they've actually produced some new ones as well.
Okay, so in terms of learning objectives, we hope you've obtained a sense of the change from the highlights that we brought to your attention of some of the changes, significant changes over the last few years, which we would say has really been a period of astonishing change. We've touched on what's likely to happen in the next few years, the big events that are looming in terms of the referendum, devolution, and the impacts that they're going to have on employers. We've highlighted the importance of good housekeeping to businesses, and what we mean by that is to remove complexity and prevent costs. So our first call to an employer would be to ask them to send the documentation so we can review what's there and we can advise accordingly. Sensible, well-considered documentation, audits and established good practice and procedures really do put employers in a stronger position than would otherwise be the case.
Does anybody have any questions?
Thank you, Giles. That's been quite fascinating for me. We do have a microphone. Does anybody have any burning questions? Because I've got one.
Thank you. David Elliott of Pulse Insurance. The flexible working regulations came in last year, and we've already had one request, which we were able to agree to. Have there been many cases before Tribunal on situations where employers have declined, and what has been the outcome?
Well, we had one. I've been involved in one very recently. Yes, there's been plenty, let's put it that way. I can only cite one from immediate personal experience in the past 6 months. That was a very complicated case with a female employee, actually in an HR department, several years' service, very experienced in HR, knew full well what she wanted out of life and knew full well what she wanted in terms of flexible working, and wasn't getting it, so therefore brought a claim for discrimination arising on the grounds of indirect sex discrimination, on the basis that the change she was requesting was a reasonable one, and by refusing it we were indirectly discriminating against her on the grounds of sex. That case, I think, actually is still ongoing. Yes, it's still ongoing. It's actually a colleague. I was actually involved in the initial stages of it, and a colleague is running the case. It may well settle, I suspect. I don't know for sure, but those cases are messy and drawn out and take a long while to resolve. Statistically, about 66% of cases settle, just because of the Employment Tribunal fees regime. If you have a tribunal case, they used to cost about £6,000 to fight an unfair dismissal case from start to finish. Nowadays, you're not getting much change out of £10,000 to £15,000 even for a straightforward case. Certainly with discrimination and other issues, lots of witnesses, a case will stretch to several days, costing a fortune to fight. So that one will probably settle like most cases of its ilk. We certainly would be prepared to fight them if we think there's a good case. Often flexible working requests are made which are unreasonable, and the employer does have plenty of ammunition to turn them down. But often what you find is wider issues arise that are linked to and associated with the act of discrimination. So in that one, it wasn't just a straightforward flexible working application. There was lots of sex discrimination chucked in as well to flavour the pot a bit, so we had to deal with it on that basis.
Thank you, David. Very, very interesting question. It does then beg the question whether or not all this change in the employment law, whether it's worse to have a contract that's out of date or no contract whatsoever.
It's a good question.
Well, I think it's actually surprising how much of what's in a contract that was drafted even 30 years ago would still apply today and be lawful. A lot of changes that happen are statutory changes, and they would apply anyway, regardless of what's in the contract. So a few years ago, there was a change in the law that meant employees became entitled to 28 days holiday per year rather than 20. So even if the contract says 20, statutory provision would apply regardless.
It's imposed on the contract.
Yes.
It's read into the contract, even if the contract doesn't actually say it.
What's helpful with contracts that, as I just said, could have been drafted many years ago is perhaps a disciplinary procedure that sets out the types of misconduct that are regarded by your company as gross misconduct. It's for companies to decide. Well, we all know that theft or violence, yes, violence in the office would be gross misconduct. But for other businesses, it's important to describe what type of conduct in their business constitutes gross misconduct, so you can then elevate it to being a reasonable dismissal.
The question is it better to have no contract than a bad contract, which is rephrasing the question slightly. I think, it's never good to have no contract, because technically that's a breach of the law. You are supposed to give an employee a contract within 8 weeks of their starting. But if the contract is really bad, it can cause huge problems. So if the question is bad contract or no contract, it depends how bad it is. But I've seen some that are so awful, I just look at it sometimes and think, I wish this document didn't exist. And it is such a crucial document in defining the employment relationship, and so important to get it right. I think if it's a choice between no contract or bad contract, no contract. But even then, I'd be wincing, thinking there should really be a contract here.
So how often should we review the contracts of employment, especially if we're promoting people?
Well, I mean, you should probably perhaps just have it checked out once a year, given that the employment law changes so much. It changes. There are two major dates when it changes in the year, sort of April and October. And there are often very significant changes. I mean, the government has attempted to keep the changes to just those time periods. But the changes are often fundamental. They can suddenly come out of nowhere. And if you're a small business, sweet shop somewhere, you don't know these things. Nobody tells you. Nobody rings you up and says you need to change your contracts and sort these things out. Often the changes are quite small. In a 20-page contract, it might be one clause which changes. But sometimes they might be quite fundamental, and the whole structure of the contract might have to change. The way in which they're operated might have to change. And we've been talking today about legislation, government-derived law. Case law can change in a week, completely change how a contract is formulated and should be dealt with. So these are complex issues. I think it's a failing of HR people often to think, well, I've drafted new contracts, I've drafted new staff handbooks for all my employees, my work is done, my magnum opus is complete. And in fact, that they need to go back to that document and revisit it on a regular basis. I'd say at least annually, in order to review documents properly.
Interesting. Any more questions from the floor? Yes, please.
Thank you. Philippe Gouraud is Concordia Employment Services, managed by Amband. I have a question. So firstly, thank you for this presentation. You've shown that there are factors that have led to increased claims and some factors that actually are pushing or identifying the opposite. So on a macro level, and maybe Robert, you can explain on that. What's your view in the impact of the low unemployment rate that we have? Is that pushing actually employee to rather say, forget it, I'm just going to cross the street and get myself another job because of the relative ease of finding a new job? And on a tactical basis for the other Robert, have you seen an increase in claims brought actually in county courts as an easier path to deal with like low-value claims? Thank you.
Well, I'll start first, actually. Because in terms of county court claims, not necessarily, no. I mean, I suppose, let's put it this way. Your question is, are we generally seeing a reduction in, a shift in the type of claim, how they're dealt with? I mean, we are certainly seeing some county court claims, but they're typically, you're left with just the breach of contract claims in the county court. So if you have a relatively low-paid employee, he's only after, in the county court claim, his notice pay. And most employers still have the common sense to give employees their notice pay. So if you have an employee, say he's been there for 10 years, and he's been dismissed unfairly, he's got two potential big remedies. He's got breach of contract, which is what's called wrongful dismissal, and he's got unfair dismissal. Unfair dismissal is tribunal, and breach of contract is potentially county court, though the tribunal can deal with that as well. I mean, there are still fees in the county court. And generally speaking, if any employee rings up to get advice, most advice would be to point him in the direction of the employment tribunal, because he can then pursue his notice money and an unfair dismissal complaint, as opposed to just the notice money, which is all he can get in the county court, unless there are wider contractual issues, like potentially not paying wages and things like that. So on the whole, I'd say, although there have been some county court cases involving employment issues, the employment tribunal is still pretty much the forum of choice, in my experience. In terms of Bert's question.
Well, no, from an insurance point of view, we had to undertake a review a few years ago when we saw a real peak in the number of claims that were coming with employment tribunals and recession. So starting in 2009, you could see the employment tribunal numbers went up by 40%. So you can judge from that the economic environment is absolutely vital in what you would expect as an experience with employment tribunal numbers, and that coupled with what's happening with the government's stance to try and reduce the number of tribunals from 330,000, that is a major reason why we've seen claims come down to the current levels of 110,000. So in terms of employment rates, you would expect that as well. We are in a relatively good times where it's easier to get a job at this time. I couldn't tell you actuarially what difference that makes at this moment in time, but yes, you would expect that would also feed into the experience that you would be getting.
I mean, we are seeing, in answer to your question, are employees just going over the road and getting a new job because they're put off by tribunal fees? To a degree, yes. I think that is happening, yes. There are fewer claims. But what you do find is that certain personality types, certain people who should never have been recruited in the first place because they're a nightmare, are still bringing claims. They're never going to go away. And whatever forum you give them, they will exploit it to the full. That is still happening. So, you do still see very difficult, very complex claims from very odd, unusual individuals who have an axe to grind against their employer. They have an issue with their employer for some reason, and they still bring cases, and those cases are getting much worse. So
Thank you for that. Very, very interesting question. Do we have time for one more from the floor? Yes, please, one down. Thank you very much.
John Levitt from Century. You mentioned earlier you don't have to engage with ACAS. Is there any penalty for not doing so?
None whatsoever. So some employers simply take the view, no, not interested, and it's then up to the employee to issue a claim. And in many instances, particularly, as I said earlier, dealing with the complex claims perhaps for discrimination, it's better to do that and then actually wait to see what cause of action the employee has and what their evidence is against the employer, because then you can make an assessment of the risks and take the view possibly, if you want to settle the claim, wait for the pleadings to come in,
yeah.
And then you know where you stand.
I mean, from a litigation point of view, we often have a client come to us and say, I've had an employment tribunal claim. And you say, oh, did ACAS contact you? And they say, oh, yes, I told ACAS I wasn't interested in settlement at all. And then you look at the case and you realise it's a total disaster. And then you rush back to ACAS and try and settle the case via ACAS. So, I mean, ACAS remain involved throughout the entire process. Early conciliation, I think, to a degree, is working. It's forcing employees to actually get clear in their heads what they're actually claiming. What you often have with litigation is a bit of a fan dance for several weeks or months even, where the claimant brings a claim and you say, all right, what do you want? And the employee says, I don't know, make me an offer. So you make an offer of, £100 or £500, a de minimis offer. And they say, that's outrageous. So you say, all right, what do you want? And they say, I don't know. And that happens an awful lot. You end up, that process can take an awfully long time trying to get people engaged. Having ACAS involved from the start, the ACAS office on the phone to them saying, you need to tell the other side what you want. And actually just having them involved at the start does help to that degree in terms of litigation. But as I say, it's having unintended consequences in the sense that claimants who would have been out of time, 10 years ago, are now not out of time. I don't really get cases struck out for being out of time anymore, which is lawyers love technicalities. We love winning a case on a technicality, and it doesn't happen as much as we'd like these days. So there we go.
And on a technicality, we've run out of time. So would you please join me in thanking both John and Robert. We do have a prize draw, so I'm going to ask John to hold the bar and let Robert draw it for the bottle of champagne.
David Savage.
David, well done, David. That's you, well done. Come up and get your bottle of champagne. Put it on your gift and hospitality register, and I'm sure it'll be fine with the FCA.
Oh, let's do. I think we need a photo.
Got to have a photo. I thought you said left the price on it for a minute. Thanks very much. So thank you very much and well done. Obviously, there's probably many other questions that you would like to raise. I know the guys are going to stand around. We'll have teas and coffees outside, so please stay around. And there are some other Abbey legal people around, so please have a chat with them while you're here. Just a couple of quick ones, if I may. Not forgetting, of course, on the 1st of July, we have our very first conference in America Square. If you have signed up, brilliant. If you haven't, will you please talk to Teresa, Jane or myself. We should be sending out, probably early next week, an email. If you haven't got it by Wednesday, please give us a shout, because you may have got mixed up, and we'll get that out to you. So thank you for that. We actually will be back here on the 14th of July, and it's not that far away, with Flood Re. And don't forget, of course, we do have our forums. But again, will you please join me in thanking John and Robert for their excellent presentation.